Government of Zimbabwe, under the leadership of President Emmerson Mnangagwa, is determined to attract public and private investment as a vehicle for advancing economic recovery. The President himself has appealed to the international community under the banner Zimbabwe is open for business, thus to show that Zimbabwe is ready and willing to accept foreign direct investment. However, at this point in time, it becomes pertinent for the investors in and out of Zimbabwe to know what is the investment law in Zimbabwe is and what is the history of investment law in Zimbabwe from the Zimbabwe Investment Agents Act up to the Indigenous and Economic Empowerment Act and now the Zimbabwe Investment and Development Agents Act Chapter 14.37. And what is the purpose of investment law here in Zimbabwe and how Zimbabwe itself has managed to make use of Section 34 of the Constitution, which states that states must ensure that all international conventions, treaties and agreements to which Zimbabwe is a party are incorporated into domestic law in order to incorporate treaties such as the Southern Africa Development Committee Model Bilateral Treaty signed in July 2012, which proffers investment laws between the host states and investors who wish to invest in that particular country. Well, my name is Christian Shiringo, and I'm a Party 2 law student from the Faculty of Law at the University of Zimbabwe. And today, I'm here with my colleagues, and we are going to unpack an introduction to the investment law in Zimbabwe under the module Commercial Law.
Tsitsi Magadzire, and I'll be taking you through the historical background of investment in Zimbabwe. Before we get into the historical background, it is imperative for us to know what investment law is as well as what investment in general is. So investment, according to the Black Laws Dictionary, has been defined as capital committed to make income from it. So here we're talking about your intellectual property rights, we're talking about your contractual rights, we're also talking about movable and immovable property. Investment law, on the other hand, has been defined as that branch of law that regulates investment in a particular country. So to the historical background of investment in Zimbabwe. The historical background of investment in Zimbabwe has been a bit shaky. Before the new dispensation was ushered in, investment in Zimbabwe has been a bit shaky due to the fact that we had political unrest in the country. We also had sanctions as well as inflation, high rates of inflation. And so investors were skeptical about investing in Zimbabwe. Also, the legislation before the new dispensation was ushered in made investors skeptical about investing in Zimbabwe. So here we're talking about the Zimbabwe Investment Authority Act. We're talking about the specific economic zones act. We're also talking about the Joint Venture Act. So basically, this act performed different duties. We have the Zimbabwe Investment Authority Act, which governs the protection and the promotion of investment strategies that were aimed at attracting investors in Zimbabwe. We had the Special Economic Zones Act. This act particularly aimed at issuing licenses to investors who were interested in investing in special economic zones. We also had the Joint Venture Act. This act essentially dealt with the private-public partnerships between contracting companies as well as private companies. So basically what used to happen was an investor needed regulatory approvals from all of those acts, and one act needed to be preceded by another. And this was a slow process, and it made investors skeptical about investing in Zimbabwe. However, we have the new dispensation coming in with the Zimbabwe Investment Development Agency Act, which repeals the Zimbabwe Investment Authority Act, and it is coming in with a different perspective to investment. It is attracting investment, and so there's been a huge and remarkable difference in investment in Zimbabwe. Thank you.
I'm Lesley Chinjiva, and now we are going to look at the benefits or the purpose of investment laws and investment itself in a particular country. So after all that we have discovered previously, the important question that we ask now is, what is the purpose of these investment laws? So investment, the first thing there to note is investment is classified as domestic and foreign investment. So both of these parties, the local people and the foreigners, need to be protected by the law. You invest into something, you need laws to protect you, to protect your investment. I'm going to take particular attention to Zimbabwe as a developing country. What is the purpose of investment law in Zimbabwe? So the Zimbabwe Development Agency Act has a variety of sections that deal with how investment laws are supposed to be, how it regulates investment here in Zimbabwe, right? So investment law protects investors and their investments from, let's say, political risks involved into investing into that domestic country or into a foreign country. There are risks that come with that. So investment laws aim at what? At protecting investors and their investments. Okay, so this risk could include discrimination, expropriation of funds, nationalization, breach of contract, damages due to war, etc., etc. So the ZIDA, it regulates economic zones. It regulates, like I have articulated, expropriation of funds. It regulates employment and so on. This will be dealt with in detail as the discussion progresses. So now, what is the purpose of investment? Why are we so worried about investment laws? What do we get from what? From investment. So investment is very, very important in a country, especially a developing country like Zimbabwe. For example, let's say the first point there to note is investment adds to the stock of capital. So the stock of capital is very crucial to an economy because it is a determinant of productivity, economic growth. It's very important. So investment thus contributes to economic growth. So for a developing country suffering from capital shortages like Zimbabwe, there is thus immediate capital formation as a result of foreign investment. So someone could ask, what is capital formation? Capital formation can be defined as that part of capital in a country's current output and imports, which is not consumed or exported during the accounting period, but rather is set aside as an addition to its stock of capital goods. So this really boosts economic growth. Then another important aspect to note on the benefits of investment is that it leads to creation of employment. In Zimbabwe, we have been having challenges in employment creation, but as a result of investment, many companies will open, multinational corporations, and this creates a need for labor. So this in turn will boost the lives of people. So investment leads to opening up of new companies, which later leads to what? Demand for labor, then that's employment creation, thereby lowering what? Unemployment rates in Zimbabwe. This also fulfills Section 14, subsection 2 of the Constitution of Zimbabwe, which states that at all times, the state and all institutions and agencies of the government at every level must ensure that appropriate and adequate measures are undertaken to create employment for all Zimbabweans, especially women and youths. So basically that's the importance of investment in our country, in Zimbabwe, including also upgrading of infrastructure facilities like roads, transfer of skills in technology and management. So basically that's what what we had discussed on that.
I am Jekwa and I'm going to introduce you to the ZIDA Act. The ZIDA Act can be cited fully as the Zimbabwe Investments and Development Agents Act, Chapter 14.37. It is an act that was established to provide for the promotion, entry, protection, and facilitation of investment, to provide for the establishment of the One-Stop Investment Services Center, to repeal the Zimbabwe Investment Authority Act, Chapter 14.30, the Special Economic Zones Act, Chapter 14.34, and the Joint Ventures Act, Chapter 22.22. The ZIDA Act combined all these repealed statutes into one piece of legislation in Zimbabwe to promote and facilitate both local and foreign investment in the country. So I'm going to move on and look at how the ZIDA Act regulates the employment of workers at special economic zones in Zimbabwe. The ZIDA Act provides for work permits for the senior expatriates from the investor's country into Zimbabwe, but these are to comply with the laws of Zimbabwe. Investors will be allowed to appoint any person regardless of nationality as a manager, technical expert or advisor with respect to the investment, provided that these persons are qualified for the job. Thank you.
My name is Viola Mhaka. I'm going to give a summation of the powers of the Zimbabwe Investment Development Agency. I'm going to give a summation according to the guide of the Zimbabwe Investment Development Agency Act, Section 4, Subsection 3. The agency has the powers to monitor the operations of the registered investments. That is, the agency has the power to ensure that there is compliance with the domestic legislation and any conditions subject to which an investment license was issued. It is also empowered to visit and inspect any premises having any connection with the investment or proposed investment referred to in the license, and it may also examine and make copies and take extracts from the financial statement. It also has the power to promote, plan, implement investment strategies such as image building, investor targeting, benchmarking, etc., for the purpose of encouraging investment by domestic and foreign investors. The agency has the power to promote the decentralization of the investment projects, which means the distribution of the investment projects to different local offices in the country. It has the power to implement or coordinate investment programs and investment promotion related activities. It has the power to facilitate entry and the implementation of investment projects. The agency also has the power to assist investors in all appropriate investment related support that may be required, such as the provision of legal and professional assistance. The agency also has the power to work with the government and interested stakeholders in using modern communication methods to promote Zimbabwe as an attractive investment destination. The Zimbabwe Investment Development Agency has the power to facilitate across all sectors of the economy, for example, the mining sector, the agricultural sector, the tourism sector, the manufacturing sector, etc., the dialogue and other consultations between the public and private sector. The agency also has the power to establish and regulate the special economic zones. The Zimbabwe Investment Development Agency has the power to appraise and recommend the approval of the public-private partnership, the PPPs, with the state. And it also has the power to develop investor aftercare services, including but not limited to post-establishment facilitation services that support investment retention and expansion. The agency also has the power to maintain records related to investment certificates, work permits, visas, and other documents pertaining to the invested licenses. And in summation, it also has the power to advise the minister on all the matters relating to the investment in Zimbabwe. Thank you.
My name is Zamanda. I'll give a summary on special economic zones. The concept of special economic zones being adopted by the government is a positive move towards economic development. These areas are granted special privileges in a country specifically for the economic development through foreign business persons to invest in that country. In Zimbabwe, foreign and local investors are allowed to invest in special economic zones. One may ask, what are special economic zones? What are the objectives of the special economic zones to the investment law in Zimbabwe? I will answer as follows. In Zimbabwe, special economic zones are designated geographical areas where business activities in those areas is subject to different rules compared to the rest of the economy. In Zimbabwe, we have places where which were declared as the special economic zones. These are Harare, which is in Sunway City, an industrial park for granite pollution. In Bulawayo, the Belmont, Kelvin, Donington, and Imvumwila trade in the industrial areas. In Victoria Falls, we have the solar energy hydrokinetic energy plant. On the 7th of February 2020, the government of Zimbabwe gazetted the Zimbabwe Investment Development Agency Act, Chapter 14.37. The Act replaced the Special Economic Zones Act, Chapter 14.34. The ZETA Act became the effective act which regulated and governed the special economic zones in Zimbabwe. The ZETA Act is aiming at boosting investment in special economic zones and make special economic zones an attractive investment opportunity in Zimbabwe. The Act incorporates on how to deal with investors separately, as this lessens the burden of investors and make easier for them to register their companies and start all their operations.
My name is Denzel Musindo, and I will be looking at the public-private partnerships. Under the ZETA Act, public-private partnerships are incorporated under Section 34, and they can be described as long-term arrangements between a government and the private sector. Typically, this involves the injection of capital by the private sector within the public sector, and this capital will be retained by the investors as the capital multiplies. Zimbabwe has witnessed a paradigm shift in the conduct of business, particularly within public parastatals. Recently, under the new dispensation of President Mnangagwa, we've witnessed the public-private partnerships of the National Railways of Zimbabwe with other private entities. Railways of Zimbabwe has partnered with the Turkish government towards the rehabilitation, the revamping, and the recovery of the railway sector in the country. Basically, this will look at the rehabilitation of coaches, thereby improving mass transportation systems and improving carriage of cargo for commercial purposes. Thank you.
Part 5, Section 22, Bracket 2 of the ZETA Act provides that for the application of an investment license, any person wishing to invest in a special economic zone must apply for the investment license, and the license should be accompanied by the prescribed fee. Part 6, Section 31 of the ZETA Act provides that for establishment of special economic zones, the agents may by judicial notice in the Gazette declare any area or premises to be special economic zone. The geographical area in which shall be defined in the notice. Besides the ZETA Act, there are a number of statutory instruments that have been made towards the support of the special economic zone. Regulation 3 of the Customs and Excise Rebate Regulation Statutory Instruments 59 of 2017 provides that for the rebates of duty of raw materials, intermediate products, equipment, and machinery, as the Commissioner of the Zimbabwe Revenue Authority may approve when solely goods are imported for use specifically on the special economic zones. The main objectives of the special economic zones is to promote from domestic and foreign sources the development of infrastructure and the creation of employment opportunities. Thank you.
We are now moving to the guarantee against expropriation. So what the Zimbabwe Development Agency Act does, it offers a guarantee against expropriation. This guarantee is enshrined in Section 17 of the ZETA Act, which adequately provides for recourse in light of expropriation of alien property. Generally, the principles within this statute is that No investment shall be nationalized or expropriated either directly or indirectly. The enactment also ensures adequate and effective prompt resolution and compensation should there be any expropriation. And this is also further highlighted in Section 17, subsection 5 of the Constitution. Several factors are considered when establishment whether indirect expropriation has occurred, which include the economic impact of the measure of series. Although the sole fact that a measure of series has an adverse effect on the economic value of an investment does not establish that an indirect expropriation is occurred. So one of the key cornerstones of this provision in this section is that the guarantee ensures that there is prompt and effective adequate resolution of disputes should there be any disputes in light of the investment. So investors are guaranteed of fair and equal treatment before the law should there be any dispute which arises during their course of their business within their specified investment areas. Thank you.
And go.
My name is Lethukuthula Nkomo, and I'm going to take you on the brief summary of the historical background of international foreign investment law. The international law on foreign investment has passed through some history. The first attempt to create the rules to govern the conduct of foreign investment was made by the United Nations Conference held in Havana after the Second World War in 1948. The end of the Second World War was marked with large-scale nationalization. The need was felt for creating a broad organizational framework for the post-war economy, and the first attempt was made to formulate international principles concerning foreign direct investment in the Havana Charter of 1948, which also established International Trade Organization, which dealt mainly with international trade. The Havana Charter for International Trade Organization recognized the need and importance of international investments under Article 12, which states that international investment is of great value in promoting economic development and reconstruction and consequent social progress. Article 12 called upon states to enter bilateral and multilateral agreements relating to the opportunities and security for investment. I'll move on to investment treaties. International investment law largely comprises of more than 3,200 international investment agreements and bilateral investment treaties and investment chapters in preferential trade agreements. The world's first bilateral investment treaty was signed in October 1959 between Pakistan and Germany. Since then, the number of such treaties has grown steadily. The most dramatic increase took place during the 1990s, the decade which marked opening up of most of the economic liberalization and globalization measures. Currently, there are more than 2,500 bilateral investment treaties in force. The investment treaties aim to attract foreign investment in order to promote economic development. This is done by providing foreign investors and their investments with certain protections, including some protections that go beyond those available to domestic investors. These include obligations on the home states not to expropriate property, not to discriminate against the investor, and to provide fair and equitable treatment to the investor. I will now delve into the sources of international investment law. The recognized sources of international investment law are enumerated in Article 38, subsection 1 of the Statute of the International Court of Justice, the judicial branch of the United States Nations, which obtains its jurisdiction by the consent of all member states of the United Nations. This provision is the most widely cited point of authority for the definition of international investment law. Some of the sources include the International Center for Settlement of Investment Disputes, the bilateral investment treaties that I mentioned earlier, sectoral and regional treaties, customary international law, general principles of law, unilateral statements, as well as case laws. Thank you.
Varaidzo Moyo. I'm going to look at the relationship between international investment law and Zimbabwean investment law here in our country. All right, let me start by answering the question that many have. Is there really a relationship between international investment law and our domestic investment law here in Zimbabwe? I would answer that as a yes. Indeed, there is a relationship between the two. These two branches of law depend on each other. However, as for our Zimbabwean investment law, it is largely influenced by the international investment law. Hence, I'm going to take a look into our supreme law, which is the Constitution, as I unpack how it is related to the international investment law. Let me start by section 326 of the Constitution, which says that customary international law is also part of our law here in Zimbabwe. What this implies is that it is applicable here in Zimbabwe. However, this section doesn't end there, but it goes further to explain that there are exceptions to this, in that the customary international law is only applicable here if it is consistent with the Constitution and also an Act of Parliament. Hence, I will refer you to section 2 of our Constitution of Zimbabwe 2013, which also states that any law or custom that is inconsistent with the Constitution of Zimbabwe is invalid to the extent of its inconsistent. What this implies is that it will be ultra vires the Constitution. As we all know, the Constitution of Zimbabwe 2013, that is our supreme law of Zimbabwe. It is sui generis and in a class of its own. Hence, any law that will be inconsistent with it cannot be applicable here in Zimbabwe. Then let me also refer you to section 34 of the Constitution, which further said that the state sort of has a duty to incorporate any international agreements or convention that it was part of into our domestic law here in Zimbabwe. However, it's not just a matter of being able to be part of that convention or treaty, but there are certain requirements or formalities which are supposed to be met before we incorporate any treaty here in Zimbabwe. I'll guide you to section 327 of our Constitution 2013, which said that any international treaty which is executed by the President or under the guardianship of the President, section 2A, it is not binding on us until it is approved by the Parliament, and also it is not part of our law until it has been incorporated through an Act of Parliament. What this implies is that the Parliament is supposed to approve of that treaty for it to be binding on us. It does make sense why they include the Parliament. The Parliament is part of the legislation which is responsible for lawmaking, and also as the Parliament, whilst it is sitting, it represents the people on the making of the legislation. Hence, it is also important for us to consider that international law, which includes international investment law, is also applicable to us in Zimbabwe, according to section 327, 326, but mainly on 327. It has to be approved first. If it's not approved, it's not part of us. If it's not incorporated into the law, there's no way we can enforce it here in Zimbabwe. So, international investment law, it is indeed part of our law here in Zimbabwe. Then as I go further to section 46, of the Constitution of Zimbabwe, the judiciary here in Zimbabwe is being sort of like motivated to also include the international law when it is interpreting the law here in Zimbabwe, especially the Declaration of Rights under Chapter 4 of our Constitution. That part is supposed to be interpreted in acknowledgement of the international law as it is, because it is part of our law here in Zimbabwe, as long as it is intra vires the Constitution. If it is ultra vires, we cannot apply it in Zimbabwe. So when I'm talking about the international law as it is, and how it's been incorporated, how it's been accepted here in Zimbabwe, I'm also including the international investment law, like from its foundation and how it is being used here in Zimbabwe. So that is how our Constitution is crafted to acknowledge the international investment law. They depend on each other. That is how it is. So Zimbabwe is a member of many international treaties that regulates the operation of the investment industries. Some of these treaties which Zimbabwe has been part of and which it has domesticated some of those laws are the Common Market of Eastern and Southern Africa, abbreviated to COMESA, and also the Southern African Development Community Model Bilateral Treaty, which I have abbreviated to SADC, NBT, among others. So we are going to mainly focus on the Southern Africa Development Community Model Bilateral Treaty and how its policies have been domesticated into Zimbabwe to govern the relationship between the hosting country and the investors as they conduct their business. One should also note that when there erupts a dispute between investors and the hosting country, the law here in Zimbabwe is allowed, as I've mentioned prior, that's for it to refer to international treaties so that they can solve that dispute between the hosting country and the investors. So the SADC model bilateral treaty which Zimbabwe was part of was made in 2012, and it mainly emphasized the harmonization of investment policies and laws of member states. This is even seen from its introductory part. Some of its provisions concerning the investment law and investors are incorporated into a Zimbabwean constitution, as I've said, in the Constitution of Zimbabwe and in the CEDA Act, Chapter 14.37. So at this moment, I'll hand over to my other learning colleague to liberate more on this topic. Thank you.
Just to emphasize more about the relationship between international investment law and our own domestic law here in Zimbabwe, I'm here to give a clear cut on how Zimbabwe has managed to incorporate what they agreed on the SADC, which is Southern African Development Community Model Bilateral Investment Treaty, which was signed in July 2012, and how they managed to incorporate those laws they agreed there into our own CEDA Act, which was enacted in 2020. So to give a few examples, Article 4.1, 5.1, 17 and 19 of the SADC Model Bilateral Investment Treaty provides that international investors must not be subjected to discrimination or to any different treatment that is given to the indigenous investors of a state member. It is also written in Article 4.1 to quote precisely that each state party shall accord to investors and their investment treatment no less favorable than the treatment it accords in like circumstances to its own investors and their investment with respect to the management, operation, and disposition of investment in its state domain. So these provisions can also be aligned to our own Zimbabwe Investment Development Agents Act, Chapter 40.37, which says that in Section 13.1, in Section 13, Subsection 1, that the agents shall accord to foreign investors and their investments treatment no less favorable than that it accords in like circumstances to domestic investors with respect to the establishment, acquisition, expansion, management, conduct, operation, and sale or other disposition of their investment. Just to give another example to show that these two are related, Section 20 of the Zimbabwe Investment and Development Agents Act and Article 11 of the treaty can be argued to be singing the same tune. Section 12 of the Act provides that investors shall abide by this Act and other legislation in force in the Republic of Zimbabwe, as well as by their contractual undertakings. Article 11 provides that investors in investment shall comply with all laws, regulations, administrative guidelines, and the policies of the host state concerning the establishment, acquisition, management, operation, and disposition of investments. I thank you.
My name is Gamuchirai Chisango, and I will be taking you through the resolutions of disputes arising from investments. Investment in Zimbabwe plays a role in harmonizing the relationship between an investor and the hosting state. This is evidenced in some sections of the Zimbabwe Investment Development Agents Act, which provides for the resolutions of disputes which may arise during the establishment, the course, and the accomplishment of investments. The Zimbabwe Investment Development Agents Act provides for legal disputes resolution. Investment disputes are under the Zimbabwe Investment Development Agents Act shall be resolved in terms of the Zimbabwe Arbitration Act, Chapter 7.15, or any other international arbitration referred to by mutual agreement of the parties. So, disputes arising from investments under the scope of the Act are governed in Zimbabwean law in terms of Section 38 of the Act, where applicable, domestic arbitration and any other international arbitration agreed to by parties can also be pursued. Foreign investors with bilateral
So, foreign investors with bilateral investment treaties that were enforced prior to the promulgation of the Act should register such agreements with the agents within 12 months from the coming into force of the Act. Any other investment thereafter should be registered within 90 days after such conclusion of the agreement. So, in summary, our presentation has discussed the background of investment in Zimbabwe. We have also explorated on what Zimbabwe Investment Development Agents Act is. We have also talked about the purpose of investment in Zimbabwe, and my colleagues have also explorated on the public partnership and also the power of the Zimbabwe Investment Agents Act, and we have also discussed the link between foreign and domestic investments. And we have also, above all, discussed and answered the questions which many people has, which is Zimbabwe really open for business? Thank you.